between 6 to 6:40. We have the team from Malik and Associates. They join us and they take your questions on immigration law and family law. And I think what's been very intriguing and informative is in the last several weeks, we've spoken a lot about both family law and immigration law and different nuances associated with it. So we have with us attorney Adam Malik. Adam, good evening. How are you doing?
Hi, Piyush. Doing wonderful. Happy to be here. And it's just me today. Joe couldn't make it, so just putting it out there.
Okay, wonderful. No, I appreciate you letting us know. And does that mean, Adam, that we're only going to be talking about immigration today?
Correct.
Okay, wonderful. All right. So, folks, just want to let you know real quick that today we are going to be taking your questions related to immigration. If you have any questions, then now is the time to call. The number to our studio is 972-235-5555. Is there something that, the entire community needs to be aware of in terms of any recent developments that really impact us and that we need to be, mindful of?
Yes, Piyush, there's a few things that are going on in the background. A couple issues that I'd like to bring up. One of them is that a lot of the times what we're seeing right now, what seems like a pattern, is that the government is taking away people's cell phones at the border, which is at the airport, to go through your personal data. That is something that is happening a lot. Government claims that they have a right to take your cell phone away at the airport and go through all of the data. You do not have to share your password with them at the airport. You can refuse to do that. However, they may take your phone away and confiscate it, and they try to break into your phone and retrieve all the data. At least by doing that, you are preserving your rights if there is an issue that comes up later. That is something that's ongoing right now. The other thing, Piyush, that's ongoing is that there's a lot of delays in immigration cases. And we have seen a very good response to filing what's known as a writ of mandamus, which is a request to the court to ask the government to make a decision on people's cases. When cases are outside of normal processing times, that could be green card applications or citizenship applications, we're able to get a very, very fast decision on those cases by filing a writ of mandamus. So if your case has been pending for a while and it is outside of the normal processing time, that is an option that you may have and you may consider, and you can certainly make an appointment to come see me and we can talk further about that.
No, thank you so much for that, Adam. And I'm pretty certain that everybody, right? I mean, at least a couple of years earlier, when I was going through the process, I mean, the delays were crazy. So I'm pretty certain that people would want to call and seek your services and advice on that. Let's take our first caller on air. Fun Asia, good evening. How are you doing?
Hey, hi. I got my I-140 approved in June 2017. Since then, I changed 2 jobs, but I haven't sort of ported my I-140. So what are your suggestions on porting the I-140 with my current employer?
Well, look, it all depends on your relationship with your previous employer who files the I-140. Sometimes you want to go back and work for them after your green card is processed, or you might want to work for your new employer. If you want to work for your new employer, then you definitely want to file a new I-140 and port the priority date. If you're going to continue to work for the old one, which you may not be working for right now, but you just want to go back and work for them once you get your green card, then there's no reason to file a new I-140. Additionally, sometimes when you leave a job, your previous employer may revoke your I-140, and you might want to file a new one to make sure that you can keep getting your extensions. So those are some of the reasons why you need to really consider. My suggestion generally is to get a new I-140 filed by your new employer, and you should have a deal with them in writing sometimes before even taking on the job that they will file a new I-140 or start the process within 90 days of you starting your job with them, because you never know, something can go wrong and they may not live up to the promise that they make you. So that's why having it in writing as a contractual obligation can always come in handy. I wish you all the best.
Thank you, Adam. With that, we will take our next caller on air. Fun Asia, you're live on air. Please ask your question.
So I have a question on my in-laws. My in-laws were out of the country. They have green cards and they were out of the country for roughly 2.5 years. We are applying for their re-entry permit. So my question is, for the citizenship application, will this period for 2.5 years be counted because they had the green cards but they were not physically present in the United States?
So there's two requirements when it comes to naturalization. One is that you have to have your green card for more than 5 years. So for that purpose, the 2.5 years will be counted. However, you also need to have continuous residence. And because they have broken the continuity of their residence, then the time is going to start again. So for that, the 5 years are going to start again. So therefore, it is going to be 5 years before they can file for their citizenship after they return back to the United States and start living here continuously. I hope that answers your question. I wish you all the best.
All right. Fun Asia Radio, you're live on air. Please ask your question.
Okay. So, hi, Mr. Malik. I have a brother and sister. They actually went for interview back in, I think it was April of this year, last month. And my sister actually got her visa, but my brother did receive a 221G. It's been almost 5 weeks, but we have not heard anything. What was the cause to get that 221G? So I was wondering if that's delay. Actually, my nephew is turning 21 of his age. So is there something you can help, or should we just continue to wait?
If your family's interview was last month and you've let the officers know that one of the derivative applicant is turning 21, they will do whatever they can in their ability to process the case as quickly as they can. However, please understand that sometimes the 221G, basically what 221G means is that they're going to put your case in administrative closure, which basically means they're going to put it on hold while something is going to be happening. And what that something is could be anything. It could be a background check, could be a name check, it could be requesting some documents from you, or looking into some legal cases in order to process this particular case. So that could be anything. So now, having said that, I don't know how long it will take, but if this happened last month, that's too soon to do anything to make this case a little faster. Now, if it was under 221G processing for over a year, we could certainly do a writ of mandamus that I was talking about earlier, which is requesting the court to step in and help. But in this particular case, it's too soon. So just hang in there and let's see the progress, and if it continues to be delayed, then we can talk about that later. I wish you all the best with that.
You're live on air. Please go ahead and ask your question.
Yes, I was trying to find out what's the process of filing a writ of mandamus.
That is something that an attorney does with the court. You can certainly try to do it yourself, but you need to have a lot of experience and knowledge about the process. Now, I can't go into all of the details because there's too much to cover, but you have to file a case with the federal court, and then you have to follow all the processes to let the government know that a case has been filed. Once the steps have been processed, then the government usually has 60 days to respond. And 90% of the times, if everything looks good, the government usually processes your case and makes a decision on your case very, very quickly. So that is something that you can certainly do if your case is delayed for a long time. I wish you all the best with that.
Thank you, Adam. With that, we are going to take our next caller on air. Fun Asia Radio, you're live on air. Please go ahead and ask your question.
Okay. My question is, my parents are green card holder. They have been coming and going to the country. So I was listening to the prior question, and I learned that they have to be continuously living in U.S. for 2.5 years if we want to file citizenship, right? My question is, within that 2.5 years, they must not leave U.S. for even few months or few days, or how does it work?
So let me repeat this. I never said that they have to be here 2.5 years. The continuity has to be there for 5 years. So they have to be a resident. They have to have their green card for at least 5 years. They have to have continuous residence for at least 5 years. What breaks the continuity of residence is when you are gone for more than 6 months, or if you're not living here, if you're not working here, if you don't have a place of residence here, if you don't have apartment lease or a house that you live in, if you don't have a cell phone bill, if you don't have a bank statement, if you don't have a credit card statement, anything that anybody who lives here would generally have, if you're not filing your tax returns, if you're working overseas, those are the kind of things that breaks the continuity and can cause abandonment of the residence. Now, if you have been a resident for more than 5 years and you've not broken the continuity, you must be inside of the U.S. half of that time. But the continuity has to be for the whole of the 5 years. And you can certainly leave the country, but can never be outside for more than 180 days. I hope that answers your question. I wish you all the best.
Sir, please go ahead and ask your question. You have 40 seconds because we have a commercial break coming up, so please make it brief.
I have an I-140 from my previous employer, and my new employer filed for my I-140, and we got an RFE against it, wherein they're asking my new employer to prove the ability to pay from the original priority date, which is in 2012. So we are trying to figure out how to answer this RFE.
I want to let you know real quick, and I'm pretty certain most of you are already aware that Mr. Malik has worked as an immigration officer and has the most unique experience. He speaks 3 languages, Hindi, Punjabi, Urdu. जिस भी language में आप comfortable हो, उसमें call करके consultation ले सकते हैं, advice ले सकते हैं. And if you have an immigration question or want to file an immigration case, then I would encourage you to call Mr. Malik's office. The number to call is 214-881-2100. That is 214-881-2100, or you can also log on to their website. That is malik.law.
So basically, the gentleman wanted to know, he's got an RFE from a new I-140 that the current employer has filed, and the government is asking for the ability to pay from the original date. I think this is a case where maybe USCIS may be overreaching their authority, and I don't think they cannot do that because the company may not even exist back then, right? A new company can file an I-140 and take over the priority date for an I-140 that was previously filed by a different employer if it is within the same category. So having said that, I don't think that they can ask for the ability to pay from that point. I think they can ask for the ability to pay from when the employee was brought on or when the I-140 was filed. And now there may have to be some kind of research, legal research done to be sure and cite some case law, and that is something that your attorney who's handling the case would have to do for you. That is basically a question of law that case law could possibly resolve, and that is something for the attorney who's going to be handling your case, and most likely it's going to be an attorney for your employer, and they should be able to do that. I wish you all the best with that, and I wish you all the best. Thank you.
Fun Asia Radio, you're live on air. Please go ahead and ask your question.
Yes, Mr. Malik, my name is Khan, and I am U.S. citizen, and I applied for my wife in August last year, end of August, and my case is in Nebraska, the immigration office. And last time I spoke with you 4 or 5 months ago, you said I should get some message or email or anything in 7 months. So it's been like almost 10 months, So I'm wondering where they will, what's the situation, when they will contact me or something.
Now, if your case is out in Nebraska, the best thing that I can suggest to you is go to the USCIS processing times, and you can Google that, and you can look at the I-130 for Nebraska and see how long that is going to take for somebody who's filing for a spouse. And having said that, if it is outside of the normal processing time, you can certainly think about filing a writ of mandamus, and that is something that I can help you with. Obviously, that is something that you have to look into after the case gets outside of the normal processing time. If that is something that you want to do, and you certainly have that right, you can certainly contact my office and we can help you with that. Other than that, you have to understand that there is a lot of backlogs with USCIS right now, and they're delayed in a lot of cases. They are trying to catch up. They're doing weird stuff where sometimes they're doing the cases who are recently filed, getting them out, so catching up on those, and then slowly working at the backlog. And sometimes they're working on first in, first out basis, and that's why there's some kind of random delays that you're seeing. And that is because of, one, the COVID situation, and second, because of the administration under Trump delayed everything, and that is the reason why we're seeing this backlog. Now, having said that, like I said, you have the option to do a writ of mandamus. If that is something that you want to do, please reach out to us. I wish you all the best.
All right, so you're live on air. Please go ahead and ask your question.
Hi, Mr. Malik. My name is Siraj, and I have applied for the citizenship in February, and so I got a time for processing time is almost 10 months. During this time, can I travel back to my home country?
The answer is yes, you may travel to your home country or outside anywhere outside the United States, but keep it brief and make sure that somebody is watching your mail, or if you don't have one already, create a USCIS online account so you can get the updates about your case right away. So if you're scheduled for an interview, you know that you've got one coming and you will be returning before that time so you don't miss that appointment. I wish you all the best, and
so we have a caller, Adam, who has a question on family law.
I'm happy to answer that.
Okay,
that's
wonderful.
No problem.
All right, thank you so much. Good evening. You're live on air, ma'am. Please go ahead and ask your question.
Hey, Mr. Malik. Hi. So my question is, if during a divorce proceeding, if a child custody is involved, does the child custody needs to be solved before? Is there any decision on the divorce case?
Usually, generally speaking, the child custody, if that starts within the same lawsuit as the divorce, then both matters get decided kind of together because, they like to wrap up the case at the same time. Now, if for some reason the child custody was taking a long time and one of the parties wanted to remarry, or there was some situation why the divorce needed to be finalized beforehand, your attorney can make a request to the court and get a decision on the divorce part of the case and continue the child custody part of the case. You can always make that request. Whether that gets granted or not depends on the judge, but you can certainly make that request. But generally speaking, they both get resolved at the same time. I wish you all the best with that.
Thank you, Adam.
And so, Piyush, do we have a question for you now? Let's do that.
No, absolutely. I think I've waited for long enough.
I've been excited and anxiously waiting. I don't know what you're going to throw at me.
No, this is amazing. You know what? Because the phones, the people just continue to call. I mean, it is incredible. It just amazes me that I waited for 10 minutes every time. I'm like, no, this time I'm going to, ask my question. Somebody else calls. Anyway, so I think here is my moment. So I read, Adam, somewhere that, there was there was a presidential commission that voted to process all green card applications within 6 months. Now, I know that in our Indian community and Pakistani community, there are people who've been waiting for years together, for almost a decade, right? And in my own network, I got this question saying, hey, what's happening? Do we actually expect a decision on our case sometime soon? So could you elaborate a little bit on that?
Yes, so I think, Piyush, there's a disconnect for people, and I will try to make that connection for you. When you read something about green card applications moving quickly, that means for the people who already have a visa number available.
Okay.
When you talk about people who've been waiting for years, usually employment-based cases, that is because a visa is not yet available. There's a waiting time. Only a certain number of visas become available within that category every year. So if they are out of those numbers, for example, let's say 10,000 visas are available under the employment 2 category, and if there are more people in that category, not everybody is going to get a green card. So they are going to have to continue to wait for the next year and the next year and the next year. And that is why there is that delay, because the number of visas available are limited. What you're talking about is the backlog. So people who have filed their green card application, the visas are available, but the government is processing them slowly. That is what you are talking about, not as, we're not talking about when visa is not available. So there are two different, very distinct things.
Okay, wonderful. And just, to kind of summarize this for everybody, what you're saying is that the priority date needs to be current for the government to go ahead and process the backlog. If you
process the green card application,
okay.
That's correct.
All right, wonderful.
So, yes, that is correct.
All right, with that, we are going to take our next caller on air. Fun Asia, please go ahead and ask your question.
Yes, I have a question, and my question is, if a person already has a green card and they kind of were in the United States for 3 years already, but due to the COVID situation, they were stuck in India and they exceeded the amount of months, like about 6 months to be in India, and then after that, within a year, they were still back. Will they still be qualified for applying for U.S. citizenship, or it resets to 0? The question is that.
Okay. Is this person married, and were their spouse in the U.S. while they were in India, ma'am?
So this is for my mother, and she's married, but my father is no longer there. So the question is about that. So she did stay here for 3 years. She's still staying with me, but during that COVID time, there were no flights, so she couldn't fly back. Yes.
Okay, I understand. Please listen to the answer off air.
Thank you.
So generally speaking, the answer is no. If your mother was stuck in India for more than 6 months, the continuity breaks. So the time will start from 0. Now, there is also a presumption that can be rebutted if she returns within 1 year and the stay outside of the U.S. was not more than 12 months. But with that, you would have to show that she did not leave the United States and never intended to leave the United States continuously. So you would have to show something back at home here in the U.S. For example, if she was working, that she continued her job. If she was not working, then if she was going to school. If she's not going to school, then something else that shows that she was only going to India to visit and her life was here, like bank statements and credit cards and other, maybe bills in her name. I don't know if she drove or, if she had car insurance payments that she was making. So you would have to show that her life was continuing here in the U.S. while she was stuck for more than 6 months in India. And if you're able to do that, then there is a rebuttable presumption that can be overcome. I wish you all the best with that. So I think, Piyush, I think the overwhelming number of questions that we get right now is about people who are seeing delays in their immigration cases being processed. If your case has been processing for longer than longer than normal processing time, and it's been outside of the normal processing time, my office can certainly help by filing a writ of mandamus for you, and that is basically requesting the court to step in and help and tell the government to make a decision on your case. I have had some wonderful results by doing that. If this applies to you, certainly reach out to my office and make an appointment.
Thank you so much. Like always, I think this is incredible community service, and people call us every now and then. They're like, hey, you know what, this is amazing. So I just want to convey what the entire community feels about this. Folks, I want to let you know real quick that we have this segment with attorney Adam Malik from Malik & Associates every Tuesday from 6 to 6:40 p.m. So just in case if you have any questions, then you can call in. The number to Malik & Associates is 214-881-2100. I'd repeat that again, 214-881-2100. Adam, thank you so much for joining us this evening.
Thank you, Piyush. See you guys next week. Thank you.
Wonderful. Thank you.